the video that we started on yesterday. The I forgot the title just that quick. I literally forgot the title that quick. That's crazy. Oh, wrongful arrest breakdown. Officer Christopher Buckner, is he a bad cop or is it just a legal failure? Now, those of you that were here yesterday, bear with me for a minute because I'm going to get to a couple places I didn't get to properly on yesterday. So probably the first 10, 15 minutes, you might want to take a sideline seat and just refresh your notes until we get to a point to where the restructuring is done better for you. All right. So the one thing we talked about yesterday was the means of challenging everything. And we started off with challenging the stop. Now, where we started at was the challenging of the stop is your first defense. And any traffic citation, any initial litigation, anything of that, you challenge the initial look. Hey, shoot me email real quick, and we can go ahead and get working on that today. It should be in the description. All right. The first line of defense is basically challenging the stop and the arrest. So in this case, we spoke about the suspect that were leaving or shoplifting at a Walmart in Rankin, Georgia, and they were leaving in a red Jeep Grand Cherokee, and two others left on foot. Keywords, left on foot. Now, James Williams did not match the suspect description, and the vehicle he was in did not match the red Jeep Grand Cherokee. Now, the context of it was the officer had a physical description of the suspect, had a location description of the suspect, also had a vehicular description of the suspect, none of which matched the person he arrested and charged. Now, Officer Christopher Buckner, I even spoke about him going into his past arrest and things of that nature. Now, under Terryville, Ohio, the police must have specific and articulable facts rising from a reasonable suspicion of criminal activity to justify even a brief stop. In the context of this, he had a description that didn't match, whether it was physical, the vehicle, and also location. All of those were not a match. He then lost the battle on that. Now, the context of why that's important is because now this is how you weaponize it against not only the police department, but the city of Rankin, as well as the state of Georgia, because they excused his action. They exonerated him, saying, oh, you didn't do anything wrong, when in fact, everything he did was wrong. And the biggest part of it, it wasn't a vague fact. It was actually something that was very tangible. The only match literally was his skin color and that he was male. The only matching aspects of this. So he lost or lacked reasonable suspicion, and there was no probable cause, which made the act illegal. Because, again, there was a clear discrepancy in what was called over the radio and what he actually encountered and chose to take part in. Now, I'm going to say I'm going over what I did yesterday because I did delete that video, but I want to make sure those that didn't catch it have an opportunity to hear it, because this one is one I want to do for the masterclass, because I'm going to give away a few secrets for the most part that can be utilized in a criminal case, and how this case will be defended if it was me doing the defense. So, because initially, the first thing I'm going to do out the gate is request discovery, and it's going to be a detailed discovery, which is going to include that CAD call as well as the dispatch calls. And is also going to be followed by motions to suppress and a dismissal motion, because these things, again, lacked probable cause. So arresting someone without probable cause is also illegal. Now, the next part of that is the reason why I'm going to do a layered defense is because I'm going to set up civil litigations, or at least the opportunity for it. Because a lot of times what happens is we'll get overzealous and we'll get excited because we have something this horrific, and we'll just go in and do a dismissal. Then we'll go to sue, and then we don't have evidence to support our suit. So therefore, we give the court a reason to side with the police officer. Where in fact is, if you will go ahead and lay the foundation, you can now go ahead and do it without waiting. And even sometimes have a simultaneous action. Because sometimes that's also the best action. Now, going into this, even the federal court has recently affirmed arresting the wrong person without probable cause is a flagrant Fourth Amendment violation. In fact, federal courts affirmed that it violates the Fourth Amendment to put the wrong person in jail when there are obviously observable differences between the individual and the person described as the suspect, and there was plenty of time for the officers to verify their identities, but the officers ignored the red flags. The context of this is challenging officer discretion, because most people don't realize that is a choice. It is a conscious choice that the officers made when he decided, Christopher Buckner decided to arrest a man who did not match the description, did not match the location, and did not match the vehicle. None of those matched. He even was told at the scene, Mr. Williams is not one of the people that were involved. Now, here's the next part. He used the fact that Mr. Williams fought back because he walked over and grabbed him. I've given the story several times in which I had a police officer grab me while I was with my son without saying anything. And just a natural reaction, he grabs my arm, I turn around and immediately hit him in the throat, because that's just a conscious response for me. You touch me, I don't know you. The first thing in my mind is to hit you, and to hit you in your throat as hard as I can, because I'm getting you off of me. I'm creating space. And in that instance, the officer, he was upset. He attempted to charge me, but hell, I sat there and waited for him to get other people there, because whenever I hit him, he pulls his badge out while he's choking. So I'm sitting there waiting. Other officers come. His supervisor says, hey, you were wrong. If you arrest him, and you're going to have an issue because it's not going to stick. So he told me I can leave, just understand, blah, 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 blah. I don't understand anything. Don't touch anybody. You didn't announce yourself. You're in plain clothes. Like, why are you grabbing me? That is an instinct. I'm a grown-ass man, and for the worst part of it, I'm 6'4" and I'm 300 plus pounds. You don't grab me. That's not something I'm responsive to. Because yeah, I'm not a surprise person either. You don't just pow. It's literally instinct. But even in that, in Georgia, you have the right for an unlawful arrest or detainment. The Supreme Court has ruled, and is also it's law, in federal law, but it's also from the 1800s. But Georgia has ruled, I believe, as recent as 2022 or 2023, that you are allowed to resist an unlawful arrest. Walking up and grabbing someone out of uniform is an unlawful detention and an unlawful arrest because of the physical contact. When you're attempting to stop someone's locomotion, that is a detainment. Even if it's multiple officers going into a flanking position, that is a seizure. Now, that's according to law. So you are allowed to resist with I forgot what equal force for the most part, because they use a different word, but it means equal. So understanding that is going through and trying to charge him with that. But what happens is, after the seizure, which was illegal, everything after that becomes fruit of the poisonous tree, because the arrest itself was illegal and the arrest must be suppressed. Because even any criminal charges that stem from it, like such as the obstruction and resisting arrest, should be thrown out as tainted by the illegal arrest, and you can do that through a MAP hearing. And the mistaken identity of innocence. The police report and later investigation, Mr. Wilson was not involved in the shoplifting at all. That's what gives this the credence of not only having the charges dismissed and also laying the foundation for the further litigation, but it also lays the foundation for the fact that he was told Mr. Wilson or Williams was not part of the ring. Mr. Williams did not match the description of the suspects. He did not have the location. He did not have the vehicle. So you got 4 factors that the officer chose to ignore, which now gives him liability, and the state should have. They haven't yet. They should have dropped the case. Now, what that turns into is is malicious prosecution. And that, again, makes now the prosecutor, along with the district attorney's office and the state of Georgia and the city of Rankin, liable for those actions because they are supporting the actions of the officer, which we have determined are illegal. Because an unlawful arrest is something that is frowned upon on courts because it is a flagrant violation to the 4th Amendment. Now, one of the things I had someone actually text me on yesterday, and I think somebody just put up a few minutes ago, is asserting a self-defense action against excessive force, which Mr. Williams did in a technical sense, even in the context of me asserting a self-defense. Now, here's the 2 different contexts of it. Mine wasn't self-defense. It was actually an equal action. Now, Mr. Williams acted in self-defense because he was aggressed face-to-face. Mine isn't self-defense because mine came from a rear action. So I turned around to engage. So there's a difference. Now, there was no excessive force, but there was a force that was applied. It did not become an excessive force because my response, bow, straight to the throat, and he went down. Now, had I then grabbed his head and kneed him in his face, that would have been excessive on my behalf, no longer self-defense, and it would have escalated to something else. But the fact that I disabled him, there was no extra force that was involved in it. So these are the differences in it. While they might seem minute, these are the things in which law is structured on. So Mr. Williams, by pulling away, officer escalated to physically taking him down. Now it becomes an act of self-defense, not resisting. Him being tased in the back, him continuing to fight after being tased is an act of self-defense because the onslaught continued and until backup came, and he's allowed to continue to defend himself against an aggressor. And especially since the arrest in its totality was illegal because he was an innocent man. Now, the indicating protective resistance. He was being beaten. He was innocent, and he was not the aggressor. He was literally in a defensive posture when he was taken down. That meant the officer went outside of the officer's duty and escalated something that was not supposed to be. And even that, what you would do is go into evidence preservation. You attack the chain of custody for the evidence, because even in that, you demand the probable cause. You go on the grounds of the outrageous government conduct, and even in the separation with the motion to dismiss, it becomes that ground in which everything is revolving around, and it gives you the greatest leverage, not only for now, but for later. And again, because again, the foundation that's being laid is not necessarily for the dismissal. It's also being laid for later litigation, and you're not just holding the officer accountable. You're holding the prosecutor's foot to the fire. You're creating a liability issue for the judge. You're also setting up the city of Rincon because they are exonerating him, and also the state of Georgia because they are licensing him. These are the things that make this, when you're setting it up, is the foundation to all present and future litigation. And this is what puts you on the path to win. This is the thing that most people are not going to teach you. This is the thing that most people are not going to talk about, because this is the ugly side of it. It is important to lay the foundation, because you make sure they can't use something because you didn't challenge it. You got to make sure, even if they attempt to steal it from you, you have their words that you use against them at all times. You make sure that every base that you go across is covered. That's what this is. So understanding the detailed discovery, understanding how to lay out the motion to dismiss, how to set up the motion to suppress. Because again, you're not trying to win every battle. You don't have to. Your goal is to win the war. And in some of those battles, you're not going to be as successful as you like. And it's okay, because it's just another bullet in the chamber for later litigation. And it continues to strengthen your case, because the idea is to continue fighting and making sure that you're putting yourself in the best light possible to win at all times. Now, one of the things too is to preserve evidence on your side. You can do what they call a subpoena, not only for the discovery material, but you can also subpoena Walmart in this case, because that's where the incident happened, inside for the video for the shoplifters, as well as the outside for when they left and the altercation and the escalation by the officer. Now, there's a trick to making sure you get it from the prosecutor, and if you don't, that is also a means for getting the dismissal, because the prosecutor, because they brought charges, and if they continue to have charges because of the exoneration, they are then liable under the malicious prosecution and also Brady to have that material, because they are using that to charge you with. Now, you can actually, because I actually have a situation where a young man, he wants to do a negotiation. I don't like negotiating, but again, it's his life, his case, so that's what we're doing. So we put him in a most advantageous position so he can go into negotiations with strength. Because if you're going into negotiations and you're weak, they are going to exploit your weaknesses. Now, even in the context of something as simple as like an Alfred plea, this is one thing that's been kind of favorable lately, because it allows you to stay innocent while maintaining guilt, but not being sentenced as harsh, because it's a contractual agreement between you and the state. So these are things that you can also negotiate by putting out certain instances of public pressure if it's amicable, and also setting up negotiations with going through with what you're going to do. And even if you're going to escalate to federal court, you must, like this one will be a perfect one for federal court, because now you can have your boy Ben Crump out here and doing things of that nature, just to have publicity on it, to set up public negotiations to where you're able to go ahead and get what you're trying to get to and get out the way. Because the whole thing that I also do is not only prepare you for the outcome that I'm expecting, I'm also marching you in the direction that you're choosing in the most advantageous way, even if that means preparing for trial. Knowing what to say when you're in litigation, knowing what to say when you're sitting with voir dire, any of these things, how to look, how to dress, hell, your posture, certain instances of how to disrupt the prosecution's momentum. All of these things are necessary to be successful in this. And then the biggest issue is holding them accountable. Now, here's the great part. And I'm going to have a guest on hopefully this week, because outside of using 42 USC 1983, there's another angle that can be enforced in this situation, but it's one that will come, believe it or not, from Officer Buckner. And it will be his pattern of arrest as well as the accepted patterns in Rankin County Police Department. What does that mean? It can set up a conundrum for them, which they can't get out of. And I'm going to have somebody else come on to speak about that, because it's one of those that I knew about it, but it wasn't something that I used, because in a lot of cases, the 1983 is not the only way, but it's the most clean way in doing it. And this is one of those that's straightforward, don't have to do a whole lot of flipping around. This is what it is. And then you add the bottom precursors for it, like the unlawful arrest, the excessive force, because of the threats, the takedown, the tasing, wrong identity, the accepted choices of the officer. Because again, Mr. Williams was not a shoplifter. He was nonviolent, and he was on the property lawfully. He was no immediate threat. He was no danger to others, yet there was force executed upon him. He was grabbed, he was punched, he was hit in the head and the body. He was tased. Now, the next part of that will be malicious prosecution, because the prosecutor continued on with the case in spite of all of these things. And that then makes, again, not only the prosecutor, the prosecuting attorney liable, it makes the district attorney liable, and I also spoke about the insurance liabilities that they are. Here's the next one, and this is why this part is why I want to have someone else come on, because they use this case more often than I have. And it's for an equal protection right that can be added onto this one, because this case, it applies. And in the context of equal protection, they would not be able to get out of it, because in the equal protection matter, only one element needs to be proven, and is literally proven in this context. But again, this is not something that I use often. It applies in this case, and I'm going to bring someone on that does use this to speak about it. So I'll bring this up when they actually come on, so you guys can actually get a grasp of what it is that I'm talking about. And what you would do, you would bring these against Officer Buckner in his individual capacity, against the city of Rankin, the police department, and the state of Georgia. And this would be a Monell claim under Monell v. Department of Social Services, 1978. It requires the showing of an official policy or custom of the municipality was the moving force behind the constitutional violation. There are several ways in which that can be shown. In this one, the exoneration is how it's shown. A lot of people don't know the simplicity of how these cases are put together. It's because you follow the breadcrumbs. Now, one of the caveats that you can throw in is the failure to train and the failure to supervise. Because even in the context, because remember I told you, he was told, Officer Buckner was told, Mr. Williams was not one of the shoplifters. The identifications or identifiers that was given to him did not meet those by Mr. Williams. He was arrested anyway and accosted. All of those are violations. And even the fact that there was the prosecution continued afterwards, knowing all of these facts, this becomes a retaliatory type effect, and that counts in the litigation. And even using the 911 call or whatever, the dispatch description, and Buckner's actions, the inadequate identification procedures which go into the training of Officer Buckner. These are things in which you can hold him liable for civilly. Custom of hastiness, poorly verified stops. You can go with the different color, different type of vehicle. All of the things that go into his past arrest. These are why these claims can be effected, but can be effective in getting you to where you're trying to get to, as well as you can hold the city liable through an insurance policy, as well as the officer. Most people didn't understand that, because even when I spoke about it a couple of weeks ago, I talked about the prosecutors and their insurance. The city has insurance. And here's the next part. There's an insurance that's under risk management with the police officers that you can attach to. But police officers don't learn that way. But if you hit their pension and you tap those pockets, you have their full attention. So there's a couple avenues that you can take, and it's up to you. Now, and also understand, police officers, the risk management insurance does not pay out fast often. I'm not going to say every time, but because we've seen a couple instances where it did pay out really fast and it was unheard of. But the common thing, it doesn't pay out fast. So, because the greatest thing, I watched the video. Well, I watched the settlement of a case from 2016. It happened Monday. 9 years later, they finally got their first settlement payment. The incident happened in 2016. The young man was beaten by 5 police officers. He's just now getting his first payment 9 years after the fact, almost a decade after the fact. So yes, you're going to get paid from the insurance. The insurance is going to take as much time as they want to pay it out. So here's another thing too that you can add in, or another avenue. And I don't know why anyone would use this, but this is something that's available to you, and it's called a state tort. And in your state claims, you can cite the Georgia organic codes that apply to such things as false arrest or false imprisonment, which is the unlawful detention of a person or anyone whereby such person is deprived of their personal liberty. Again, this is when you have multiple officers flanking you and restricting your freedom of movement. That is a false arrest, false imprisonment. And this is also whenever you're told you can't leave and they have no probable cause, and there was no justification for detaining you. Now, they also have to have an articulable reason to suspect you. Now, officers don't have free reign to just do whatever they want, because they are servants at all times. Georgia state constitution, I actually read it to you. They are to be amenable to you at all times. Meaning, unless there's a crime, they are in the position of servitude. There was no crime that Mr. Williams was guilty of. He should not have been placed in that position, which made it an assault and battery, because it's an intentional infliction of harm or offensive contact. An assault is an act that creates apprehension of such contact. Officer Buckner's conduct fit both of those. Now, the harmful contact, the battery, the tasing was the assault. All of these are things that go into. You got intentional infliction of emotional distress. These are things for lawsuits on that. That is the thing that actually goes into monetary requirements. And then you also have negligent claims, negligent hiring. I did negligent retention because I spoke about the young lady down in Richmond County. And supervising, negligent supervising. Because again, even after being told by a supervisor that he was not part of it, He continued on with the action, and the supervisor okayed it. So all of these make them liable. And one of the things I did talk about was parallel suits. You can either do one in state and one in federal, or while you're doing the criminal case, this is a great one which you can file the civil case in federal court, because these are the things that will then overlie and will allow you to move if you're out, and actually work as an advantage for you. Now, I'm also going to recommend, if you're in jail, do not attempt to file a federal lawsuit, because now it's up to you to get back and forth. They don't have to take you back and forth to court when it's a lawsuit. Not criminal action, but a lawsuit. They don't have to take you back and forth. So always understand that, because it trips me out whenever I say that and people will still be in jail. They'll find a way to file it. Sometimes it's mailed out. They'll get a case number. They'll be held in jail. They'll have a hearing, and they'll miss the hearing. Now the state is out, and you can't bring it back up because the judge purposely dismisses it with prejudice. So you cannot bring it up unless you come up with new charges. And yeah, a lot of times people give out too much information, which then nullifies their entire suit. So you go through with your constitutional claims. You set up something to where you can actually make sure you're staying in the realm of what's needed for effective winning for the most part. And you press and challenge everything. Now, I'm going to run through these cases real quick just to give you an idea of what we were talking about. Terry v. Ohio offers the requirement of specificity and articulable facts for a stop of a crime. Beck v. Ohio, probable cause standard for arrest. Graham v. Connor, excessive force must be objectively reasonable under the Fourth Amendment. Severity of crime, immediate threat, and resistance. Remember, that's the factor of Connor. The severity of a crime. There was no crime. And shoplifting is minor. Immediate threat. Mr. Williams was not a threat. Mr. Williams was allowed to resist because the attack was unlawful. So, again, and then Monell is because the municipal liability exists when a policy or custom causes a constitutional violation. They were okay with his actions because they exonerated him. In Jennifer Box v. Broward County, no immunity when officers jailed wrong person despite obvious discrepancies. And I forgot to talk about that. Officer Buckner has no qualified immunity in this case. Isn't that beautiful? It's already beaten before he even goes into there. And the greatest part about it is this: now you have an idea of what it would be or what could be done to not only win this case, but to see how your case may be won as well. So that's it for right now. I'm gonna be back shortly, literally, because I'm chilling today. And hopefully you got a better grasp of the things, considering today we were not interrupted. And we now get an opportunity to see there is defense whenever police do something that's just completely out of line. So don't forget to hit the email if you need to contact me. Also set up appointments or consultations. That's also in the description, as well as don't forget to tip your boy. I like coffee. Shoot me a couple bucks for some coffee. I like Starbucks too. Caramel macchiato. So until next time, Supreme, I'm out.